The topic that we have before us today is historical developments of Nigerian legal system. And in our last class, we did a summary of what the content of this particular topic is all about. And I recall vividly that we did submit that the topic will be discussed based on major 3 timelines along the developmental story of the Nigerian legal system. So the topic will cover the historical development of the judicial system in Nigeria, and we were going to talk majorly on 3 timelines, which include the pre-colonial judicial administration, colonial judicial administration, and post-colonial judicial administration. By the time we are done with these 3 segments, we will have been able to see how the legal system of Nigeria has moved from one state to the other. So it's important to note basically here that the Nigerian legal system has moved from, different stages. And those stages were greatly influenced by the type of government that were in place at that time. And the good thing about it is that history has it on record that prior to the time that Nigeria or Africa as a whole were colonized, we as a people already have our own system of dealing with our issues. And this, include our own system of lawmaking, our own system of judiciary, that is interpretation of whatever laws that exist in the land, and also how the laws are enforced. So all of these systems, which are one way or the other, some have classified to be inferior or non-complex, whichever way they may have looked at it, the fact remains that all of the system we had in place as a people were sufficient as at that time to meet the basic needs of the society. But of course, as time progresses, we have situations where the foreigners invaded, our system, all of our system, and then they introduced a different system of trade, or what we call popularly referred to as commercial activities. And then this had a way of, altering what we as a people had, before their approval. But whatever it is that were introduced by their involvement is what has led to the present state of our judicial administration that we can boast of now. So what that means in essence is that our interaction with them as at that time laid a foundation for what is now known as the modern or the contemporary adjudication system in Africa. Then we are going to be looking at some specific aspect of this development to be able to aid our understanding. Now, for instance, we noted that in the 19th century, before Lagos was annexed we're talking about 1861, we had recognized political systems, even in our own states, in our own community. And this is to further buttress the fact that Nigeria as a people, or the area that is now known and referred to as Nigeria, had its own system that were working for us. We had our own court system, which adjudicates on matters between citizens or between even citizens and foreigners who had one or two things to do with us as a people. We look at the Igbo community. Their own system was more of an acephalous system, which is a system that does not have a form of central leadership. Rather, the leadership of the society was among the members of the community. These members who sat in council or in the capacity of legislature or the judiciary performed the various functions of the judiciary or legislature as the case may be. So all of these further buttresses the argument that we have made earlier on, that we as a people had a functional system for ourselves. When we also take a look at the Hausa as a community, even as a then, even though we have submitted over time that the system that the pre-colonial Hausa judicial system maintained is what is referred to as the closest to the modern court system that we have today, because of the fact that they had a central leadership that provided direction in terms of lawmaking, in terms of execution of law, and even in terms of the enforcement of law in the society. We had various court systems, and as at that time, we could identify courts that serve as court of first instance and courts that also serve in the capacity to receive appeal from the lower court beneath it. And then the different courts were headed by recognized officials, even though some of them may not have gotten a formal kind of training on the court system. But one way or the other, by virtue of the system that they had operated before the arrival of the colonial masters, or those who feel that their own system is superior than ours, but they've already had what was the basic things that they need to know in order to be able to adjudicate on matters that may be presented to them by citizens or people we generally refer to as indigenes or foreigners. And then one thing we also need to note about this is that as at this time that we're talking about, administration of justice within the society was majorly based
I cannot wait for April
on written
to come.
interpreted by the institutions and individuals that function in the judicial system of
I'll write my last paper.
community. So
Let's go. Let me tell you something, but let me also do.
So these functions or their activities were majorly on unwritten customary rules. Of course, those were the rules that were prevalent as at that time. And of course, the people could not have manufactured any other system of rule except what they have been used to, which is also indigenous to them. And in the midst of all of that, the society as at that time had their own different system of punishment, which were common to them and as at that time. And apart from the fact that they were common to them, they were kind of a system that the people respected. That once an individual has done something that the society considered to be a crime, or to be something that is immoral, or something that does not align with what the society believes in, such individuals are sanctioned. They punish them either by way of making them to pay fine, either by way of ostracizing them, or even by flogging. Sometimes they are also made to do some form of punishment, community service, as a way of laying punishment for acts which the society consider as unacceptable behavior within the society. But the time and season that happened to them led to the increase in growth in the European trade within the region. Both the European and the British trader also got involved with what was happening, both politics and even judicial administration. And they got involved so deeply that they began to either have issues with the existing practice and procedure that were in place at that time. And especially as it relates to issues of dispute, maybe contractual dispute, land issues between foreigners and non-foreigners. And the area of conflict also came from the angle that many of the foreigners were not familiar with the kind of rules that were operational within the society at that time. Therefore, there was need for the society to grow up to be able to accommodate both the indigenes and the non-indigene at the same time. And it was this occasion that led to the introduction of what is popularly known as consul court. The consul is spelled C-O-N-S-U-L, consul court. The British government established the consul court and appointed consul, that is officers, to handle disputes between the indigenes and the foreign traders. And while the traditional court continue to administer cases involving only indigenes, the consul court that they have formulated, that they have put in place, was able to apply both their own laws which they have brought into the country and other available legislation that can assist them to achieve their goal as a people, or as businessmen, or as people who have come to colonize the area or the jurisdiction where they have found themselves. So why the consul court came into existence, remember the traditional court system that had been in place right from time also continue to exist. Now, example of the way the British penetrated and established themselves, even established the judicial system, was the introduction of the Oil River Protectorate, which later became the Niger Coast Protectorate, and the council that they have appointed who were British officials, were made to, observe treaties and handle the governance of British subjects in that area. Meaning that all that they did had moved from mere contractual or commercial activities to the point where they now begin to introduce some political system to govern the people that were in that geographical area. So the Oil River Protectorate, like I said, later became the Niger Coast Protectorate. And this body were saddled with the responsibility of, governance, not just mere trade at this time. And then all of this also eventually led to the formation of the Courts of Equity. And that was introduced in the mid-19th century. All of these were the various developments, notable development that one could notice as at that time. There was the Council Court, which administer justice between indigenes and foreigners, while the customary courts dealt with issues that pertain mainly to the indigenes. And then we talked about the introduction of the Oil River Protectorate, which later became the Niger Coast Protectorate, and that handled issues that has to do with agreement, contract, and were also made to administer political leadership to the British citizens that were within the territory at that time. And to take it further, the Court of Equity was introduced, and the main function of the Court of Equity, which was introduced in the 19th century, was to administer the commercial relationship between the British subject and even the indigenes that they came to meet. And as at that time, there were different council courts that were, of course, less technical, and they related more to the administration of commercial relations or handling of commercial relations, governance, and justice issues. So meaning that even as a company that has come to trade, they began to administer political leadership. Apart from political leadership, they also engage even in governance. That's a simple way of saying political leadership. They engage in governance and also serve as the judicial arm at that time to manage issues that may arise between the indigenes and non-indigenes. So all of these form all that transpired, or form the summary of all that transpired during the pre-colonial era of the judicial system of Nigeria. And one of the things you should take away from this lecture, especially on the pre-colonial judicial system, is the angle that has to do with the existence of two types of system, court system. Simply put, the customary court system and the English court system. And that's why we did say that the pre-colonial judicial period and the activities like the existence of those two systems of justice was popularly referred to as the beginning of the bifurcation of the legal system of Nigeria. Because, like we said at the beginning that this entity, now known as Nigeria, had her own system of government. But subsequently, by the coming of the Europeans or the British system was also introduced to run side by side with the existing customary law system. So all of that constitutes the summary of what transpired within the pre-colonial judicial system of Nigeria. Now, the second part of it is the colonial judicial administration. I think I can see some hands being raised. I would like to take your question if I have not answered it in the course of my explanation. Yes, Adedoyin, you can speak, or who else? You only have one person. Eunice? Okay, maybe that hand was raised inadvertently. All right, so we continue with the second part of the history.
Sorry, excuse me, sir.
Yes, please.
I didn't get what you said about the customary court system and English court system. You said they were the beginning of what?
The bifurcation, more like the division of our legal system, simply put. Why do we say bifurcation? Bifurcation is spelled B-I-F-U-R-C-A-T-I-O-N. Now, for you to understand that properly, recall that we did say that before the advent of the colonial masters, we had our system which was basically on customary rules. Then when the consul court, the court of equity were later established, which were made up of the English system and English law, we now have two different systems. While the customary law aspect deals with indigenes, the other English system now manages relationship between indigenes and non-indigenes. Okay? So I believe I have been able to explain that to you properly.
Yes,
now,
sir. Thank you, sir.
Yeah, thank you. You're welcome. We move on to the second part, which is the colonial justice administration. Now, at this point, this segment that we want to look at is further divided or classified into two. We have the pre-amalgamation and the post-amalgamation period. So this colonial justice administration period is further divided or classified into two, which are, number one, the pre-amalgamation and the post-amalgamation. Now, the pre-amalgamation period covers the period between 1861 and 1914. So if you are asked in the exam, when we talk about the pre-amalgamation period, which, when and where are we referring to? What you should have in mind is the 1861 and 1914. And at this time, different parts of what is now known as Nigeria were administered by the British government or their appointed officials. Recall that we did say that when the British established those courts that we have mentioned, they also appointed consul, that is, British officers who serve to represent the British government. So what we are saying is that the pre-amalgamation period, that is 1861 and 1914, when different parts of what is now known as Nigeria were administered by, that was when they were administered by the British government. Now, the post-amalgamation period refers to the period after the amalgamation of the colony and the protectorate of southern Nigeria. Okay, that is the period of the post-amalgamation that we are talking about here. So it is the amalgamation, after the amalgamation of the colony and the protectorate of southern Nigeria with the protectorate of northern Nigeria, which is what has now formed what is popularly known as Nigeria today. So, by way of the progression of the history, after the cession of Lagos to the British British Crown in 1861, that is, after Lagos was taken as part of the British Crown, that is part of British land, the Supreme Court Ordinance of 1863 established the Supreme Court in the territory of Lagos. So, simply put, Lagos, as at that time, was an extension of the British territory. And after a while, that Supreme Court ordinance that established the Supreme Court, history added that the Supreme Court was later replaced by the Court of Civil and Criminal Justice. And as at that time, the Supreme Court was the highest court that could adjudicate on matters happening within the colony. And then later on, it was simply converted to a court of civil and criminal jurisdiction, which was the highest court in the land as at that time. But appeal from that particular court went to the West African Court of Appeal that was situated at Sierra Leone as at that time. That court, West African Court of Appeal, which can be referred to where we abbreviate it as WACA, popularly called WACA. And that was the appeal court where dissatisfied litigants from the Supreme Court as at that time will appeal to. So when an individual is also not satisfied by the decision of the West African Court of Appeal, a further appeal now moves to the Judicial Committee of the Privy Council. Of course, that is an arm of government of the British Crown that was in place at that time. So, from the Supreme Court, it moved to the Court of Civil and Criminal Justice, and appeal from Court of the Civil and Criminal Justice went to West Africa Court of Appeal, and from there, it went to the Judicial Committee of the Privy Council. But as history will have it, in 1874, another colony was established. This colony is known as the Gold Coast Colony. This Gold Coast Colony now comprised of Lagos and the Gold Coast. Lagos and the Gold Coast. And the Supreme Court Ordinance of 1876 provided for a Supreme Court for the colony. You will notice that Supreme Court as featured earlier, and when it was replaced by the Court of Civil and Criminal Justice, later on, it has now been introduced by the Supreme Court Ordinance of 1876. And again, the court was to apply, the doctrines of equity, which was introduced earlier on by the council court or the consul court. Also, the Supreme Court at that time also was also expected to apply common law and then what is popularly known as statutes of general application. So all of that, those rules were what the Supreme Court as at that time applied to Lagos and the Gold Coast. And then as time progresses, there were further developments that led to the separation of Lagos colony and the Gold Coast colony. And as at that time, both of them ended up becoming two separate colonies with separate authority, with separate judicial system, and then they apply rules that were expected of them. So let's delve into that a little by, let's delve into the history behind that. So by 1886 now, Lagos has ceased to be part of the Gold Coast colony. Remember, I said earlier that the two were later separated. Then the colony and the protectorate of Lagos, that is comprising of Lagos and surrounding protectorate, had another Supreme Court established under a new Supreme Court ordinance. And of course, those ordinances were the enabling law that brought into place those courts that existed at that time. But one of the things that we need to reiterate in all of these is that why these various courts were being introduced during the colonial administration, the indigenous court system, continue to flourish because they had advantage in dealing with cases that pertains to the indigenes. So life still continue under that court system, although when there are issues that pertains to an indigene and a foreigner, those ones are made to become subject, they are made to come under the English court. Another thing that we also noticed during this period was that some indigenes also feel that they do not want to be bound by the customary rules or by the local laws. They now began to make themselves subject to the English system. And I believe this was one of the steps taken to further make our own heritage to be less important, because indigenes now stop taking customary law and then they take it aside and began to see the English system as the system that was of more that was like a superior system. What we had was no longer important, was less important or could not be compared to what the foreigner has introduced. And that's why up to today, we still prefer to speak the foreign languages rather than even speaking our own language. I won't be surprised that there will be people in this class who probably cannot even speak their own native language, but they can speak English very well. Even in our dressing, people prefer to go for foreign dresses as against our own traditional attire that we have. So just as it is featuring today, it also featured in those days when some indigenes now prefer to be governed by the English system as against the customary law system that had governed their affairs all the time. And then by way of addition, I want us to note that all of these that began as a commercial relationship between the British traders and the indigenous Africans later became a complex political relationship in which the British authority now dominated the political scene in Africa. And that's what is popularly referred to as colonization. They've taken over the laws, taken over political system, and now they administer governance on the people. Meanwhile, when they came, all that was seen as the reason for their coming was purely commercial, that these guys have come to trade. And that's why up to date, so many people, so many Africans still feel that the Western world that, colonized us were not sincere with us right from time. And of course, that we can see that in the way which lands were taken from our forefathers by mere giving them mirror. They take acres by mere giving them mirror. They were probably taking some very valuable mineral resources that God has blessed Africa with. And then people feel that they were not genuine after all, that what brought them to us was not the attempt to develop us, but rather to enrich themselves. Now, what do we have to support this argument? There was the Royal Niger Company. Royal Niger Company began as the National African Company, a company that was doing business along the River Niger. The company was empowered to administer justice in the territory where it operated, and it established court for that purpose. Just like now, MTN, that is more or less like a foreign company in Nigeria, we now start playing the role of governance in the area where they function, where they are situated. Start playing the role of the judiciary. Start playing the role of the executive. That can be described as what took place at that time. The Royal Niger Company that started as National African Company became government unto the people. And what happened thereafter was that after 1914 amalgamation, the bifurcation continued, and there were proclamations establishing different other courts. And these different other courts we're talking about still has to do with further division of the English court system and the customary law system that are elsewhere, before now. So after the amalgamation in 1914, which I believe we are not just hearing about, there were proclamations establishing a Supreme Court, a provincial court system, and a native court system. That is like three unique court systems at the same time: the Supreme Court, the provincial court system, and a native court system. Of course, if you want to look at it from the face of it, we can say that the Supreme Court was more or less like the bigger umbrella why the provincial court system were to deal with the various states, even though we're not referring to them as state then, or we could see them as provinces or various segments of the country. Why the native court system can be seen as the local or the community court that dealt with issues relating to their immediate community. For example, to buttress that, the native courts were empowered to exercise jurisdiction in civil and criminal cases concerning natives. But certain classes of natives were subject to the jurisdiction of the court only if they or the resident consented to be banned by their laws. Of course, I told us earlier that at a time, even those who were Nigerians began to subject themselves to the English law system. And then the native court system only applied to natives and those who were foreigners who were resident amongst the natives and also wish to be governed, especially on civil cases, by the rules applicable to the natives as at that time. And all of this continued. And when it was 1933, there was further judicial reform, which brought about the High Courts and the Magistrate Court system under what is popularly known as the Protectorate Court Ordinance of 1933. So simply put, the Protectorate Court Ordinance of 1933 brought about the establishment of the High Court system and the Magistrate Court system. And what this did was that it replaced the Provincial Court Ordinance, while the Supreme Court continued to exist for the colony as a separate court on its own. And that's why up to today, we still have the High Court in our system, in the hierarchy of our courts, and also the Magistrate Court as part of these other structures that we have as a country. Now, still on that, jurisdictions in matter relating to English law was shared between these courts, which had original and the appellate jurisdiction, meaning that the Magistrate Court became more like the lower court, and any decision reached by the Magistrate Court that the party to it was not satisfied could go to the High Court, and from there could go to the Supreme Court, and then from the Supreme Court to the West African Court of Appeal. And then where there are, situations where individuals were also not satisfied by the decision reached by the native court, they could appeal to the other existing court that were in place as at that time. Yes, I'll need to finish this segment before I will take a question. So all of these were part of the developmental stages that took place during the colonial judicial administration. But as time progresses, in 1954, when the federal system of government was introduced, the court system in Nigeria also adopted a federal structure, as High Court were established for Lagos and each of the 3 regions that were in existence as at that time. While there was a federal Supreme Court, the Magistrate Court for the different parts of the country also existed. And this court applied and administered English law, while the native court in the north and the customary court in the southern part of the country applied and administered customary law to those who are subject to them. Now, the law establishing the native court were enacted by the different regions. And that is why up to date, we now have different courts in Lagos, even though they share the same name with other states. Each state also now have their different courts, their magistrate courts, they have their high court, and so on and so forth. These were the various developments that took place at that time. We also need to note that at that time also, the northern region also embraced Islamic Sharia law, and they recognize that as their customary law. And then, apart from the Sharia court, they also had the Sharia Court of Appeal, where appeal could go to, where an individual that was part of a suit at the Sharia court was not satisfied. He could go to a higher Sharia court to seek for remedy. And then from there, the Sharia court, if you are not satisfied, they could appeal to the High Court, and a court of resolution was established for resolving such conflict. So all of that were the various developments that took place during the colonial time. So what can be said about this period was that this period saw the eventual establishment of foreign courts in Nigeria. Before, it was more like an attempt to do so, but as time progresses during this period, the British system of government has been made to stand and to also continue to exist side by side with the customary law system, both in the Lagos, in the northern region, and also a part that was referred to as the southern part of the country. So that is the summary of the lecture relating to the colonial judicial administration. So I will take a question now before I will look at the later part of the history, and then we can take on other things. Yes, Mariam, you have a question?
Okay, sir.
You have a question? Yes, please go
There
ahead.
was, after the 1933 Protectorate Court Ordinance, where the High Court and Magistrate Court system was established, you mentioned a particular hierarchy of courts that was used. I missed that at that moment, so I was trying to ask if you could help me.
We talked about the Magistrate Court and the High Court. The Magistrate Court was a lower court, and the High Court was a higher court. Meaning that if an individual was not satisfied with judgment given by the Magistrate Court, it could go to High Court. From High Court, it could go to the Supreme Court, and then it could go as far as the West African Court of Appeal.
Okay.
Yes.
Thank you, sir. Noted.
You're welcome. Akano.
Good afternoon, sir.
Good afternoon.
My question is, you spoke about the waka, but I didn't get the meaning.
I didn't get that.
You spoke about waka. That's
Waka is
I don't
a
know.
form of West African Court of Appeal.
Okay, sir. Thank you, sir.
It's not the usual waka that you are
Okay.
used to. Okay.
Yes, sir.
All right. Yes, Mamuyowi. Are you there?
Yes, good afternoon, sir.
Good afternoon. Yes, ask your question.
Sir, my question is not actually from this class, from the previous class. When I was going to my notes, there's some I did not really understand.
I can't hear you clearly.
Can you hear me, sir?
Can you send a message through the question and answer platform?
Okay, sir.
And your network is not so clear. Yes, I think that's all. I'll be waiting to see the question from Mamuyowi so that I can answer it as I take on the last part of the lecture, which is the post-colonial judicial administration in Nigeria. Now, this will commence from 1960 because that was when Nigeria became a sovereign nation. And when Nigeria became a sovereign nation in 1960, the political climate in Nigeria also changed. When it changed, another thing that didn't change as at that time was that the judicial structure, which is our focus, remained significantly the same. Because as at this time, the various regions were already having their high courts, their magistrate courts, their customary or the native courts. And as at that time, there was the Federal Supreme Court and the Judicial Committee of the Privy Council remained the highest court of the land. Mind you, the Judicial Committee of the Privy Council were still made of foreigners, which suggests that even though Nigeria had attained independence, it was not completely free from the interference of the colonial masters. But one significant point here is that the 1960 independent constitution brought about the abolition of criminal jurisdiction under customary law. You will remember that we did say that the customary law existed alongside with other courts, and it had the duty to administer both civil and criminal jurisdiction. But the major change that took place at this time was that the criminal jurisdiction that was given to the customary court was taken away because the Constitution provided that no one will be convicted of an offense not provided for under any written law. Okay? And mind you, the customary law system was governed by the customary law, which we have said was largely unwritten. So when the Constitution came into place, the Constitution stated categorically that no individual can be punished or be tried under Nigerian law except the law stating the offense is available, and that not that the law only states the offense, but also provided for the punishment that should be apportioned to anybody that may be found guilty of such crime. This position remains the same till today. So there was no other significant change in the judicial system until 1963. And 1963 was when Nigeria became a republic, and eventually every form of foreign participation or interference came to a complete end at that time. And of course, this was by virtue of the 1963 Constitution, which was popularly referred to as the Republican Constitution. Consequently, the hand of the Judicial Committee of the Privy Council was taken away, and the Supreme Court of Nigeria became the highest court of the land. So, and there was also the creation of additional region, which was taken from former Western region and was known as the Mid-Western region. So, the three regions existed alongside with the Mid-Western region. But one thing that will now change the whole narrative was that when the military came into play in 1966, the country was divided into 12 states. And this was done under the Creation and Transitional Provision Decree of number 17 of 1967. That was a decree that they further divided Nigeria into 12 states. And that decree is known as Creation and Transitional Provisions Decree number 17 of 1967. And of course, this coup or the military intervention that came into play or that took place at this time consequently led to the beginning of series of military coups in Nigeria. And during the period from 1967 to the country to date, the country has been restructured several times, that we now have 36 states and a federal capital territory. And what this means is that the justice system remains decentralized up to the Court of Appeal, meaning that these various states that existed, all of this time had their own court system, that is the High Court, the customary court, the magistrate court, up to date. And to further make it easy, the Court of Appeal were also made to exist in some strategic places or states, while the Supreme Court remained at the federal capital territory. And with that is what we have that characterize the current judicial system that we have as a nation today. So what only happened during the post-colonial was the further division of states and further division of the various courts that existed at that time. So there were need to create more high courts, more magistrate court to cover the various divisions that took place at that time. Then other things that happened at this time were the appointment of judges during the military regime. And of course, that became necessary by virtue of the division, further division of the courts in the various states. Definitely, they now need more and to man those courts. So what this has done basically, this class has done basically, is that it has provided a brief history of the judicial system from pre-colonial era up to the to post-independence time. And of course, major focus we saw was the bifurcation of jurisdiction, as we saw between the native court and the English court. And then the administration of justice in Nigeria since that time has sought to continue to distinguish between customary and non-customary jurisdiction. But the greatest change has occurred in the area of the non-customary system, which has become more sophisticated over time, and the coverage has widened more than the customary system because of the fact that the states, or practically indigenes, believed more in the foreign system than the customary system. And of course, that led us to embracing several foreign laws, even that now apply to the various aspects of our life as a people of Nigeria. So with that, we come to the end of the history of the Nigeria legal system. And the next topic we will take after that, which we are going into straight away, is the features of Nigeria legal system. The features of Nigeria legal system. Now, by the time we're talking about these features, you will begin to have better understanding of all that we have been talking about since we started. So we are going to talk about 7 distinct features of the Nigerian legal system. I'm going to list them first of all, and then we will take time to begin to explain them as time will permit us. The first one is duality. First one is duality. That's one major feature of the Nigerian legal system. Number 2 is external influence. I'm sure by the time I finish listing this, people in this class should be able to tell us what we mean, how we're able to pull out these features from the history that we have told. So we have said number 1 is duality. Number 2 is external influence. Number 3, major feature of the Nigerian legal system is geocultural diversity. Number 4 is the system of precedents. Number 5 is the existence of different types of law. Number 6 is order of judicial hierarchy. 7 is the fusion of the legal profession. And lastly, we'll talk about the military influence. So I would like to repeat them again, just for emphasis, and I believe individuals in this class should be able to pick them one after the other to explain to us what we mean how we were able to derive these features from the stories that we have been talking about since we started looking at the history of the Nigerian legal system. So once again, I list them as number 1, duality, number 2, external influence, number 3, geocultural diversity, number 4, the system of precedent, number 5, existence of different types of law, number 6, order of judicial hierarchy, 7, fusion of the legal profession, and lastly, the military influence. So, do we have volunteers in the house who can briefly tell us what we mean by these features that we have listed?
Good day, sir.
Yeah, good day.
Yes, I can't confidently say that I know for all the points, but at least I'll give a try.
Please go ahead.
Yes, sir. The first one, duality. This had to do with the bifurcation of the Nigerian legal system, where the customary law and then the English law coexisted at the same time. I don't know if that is correct. Then the second one, external influence. The colonial masters had interference even when they established companies. These companies, when they come in, they began to take on governmental roles, making laws and also settling disputes and taking judicial powers.
Very correct.
Then geoculture. Sir?
Yeah, I'm following you. You are very correct. Yes, go ahead.
The next one, geocultural diversity. In this this feature talks about the fact that the Nigerian that's in the pre-colonial times, they had their different judicial systems that were in place, or they had their systems that were in place. And also when the colonial masters came into power, or came in to influence their judicial system, this allowed or caused geocultural diversity, various ethnic groups or various ethnic beliefs among the people. Then system of precedence, I don't think I got that one. Then the existence of different type of laws. The common law was in existence, statutes of general application was in existence, doctrines of equity. Those were the different laws that
Udo, continue.
came that were in existence in the judicial system. As the time went on and development,
I guess network is not allowing him to make his submission.
This was the fifth one.
All right. Does anybody want to take over from where he stopped? He has actually done very well. Okay, let me quickly run through. Can you hear me, please?
Yes, sir.
Yes, sir.
Yes, let me run through them.
Yes, sir.
I'll just be adding to what Udo has said, because of course these answers were straight to the point and were very useful to the point we are discussing. So when we're talking about duality, just like he has mentioned, the system of law that existed here now included the rules of customary law, and also the English law also were both running side by side. Very, very straightforward. Then external influence. One thing we noted in the course of our discussion was that before the advent of the colonial masters, we had our own rules. But when they came, many things changed from our system because we had to copy from the various laws that they brought. And up to today, you can see that we borrowed heavily from external sources. Most of our laws are borrowed laws. We only adapted them and adopted them to suit our own system. For example, we have the Criminal Code and the Matrimonial Causes Act. These are laws modeled after Queensland in Australia, and also the Penal Code, which is also modeled after the Sudanese Penal Code. So that is an example of what we mean by external influence. Then on cultural diversity, Nigeria had well over 250 ethnic groups, and each of them had their own special customary norms, and they were different from one another. And then that talks about multiplicity of ethnic groups in Nigeria. And then it provided difficulties in harmonizing our customary law as a people. So that is one major characteristics of the Nigerian legal system. Another one has to do with the system of precedent. The system of precedent, which is also known as the doctrine of stare decisis, was also gotten from the introduction of the common law system. And this judicial precedent that we know that is a system that enjoins the earlier decision of a higher court to be binding on a lower court in a similar case. And that system is of a common law origin and is being practiced in our judicial system today. Then we have a system of different types of law. Nigeria legal system is complex because of the different laws that exist side by side. For example, we have the federal system of, we run the federal system of government that permits local government autonomy and also expect the states to also make their laws, whereas we have federal laws also in place. Then we also have order of judicial hierarchy as part of our the major features of the Nigerian legal system, meaning that we have the Supreme Court as the highest court in the land, followed by Court of Appeal, followed by the High Court of the Federal Capital Territory or the state, then the magistrate court system, customary law, and Sharia law. All of that, you see that they go in hierarchy. Then the other feature, major feature, is the fusion of the legal profession. Legal practitioners in Nigeria are trained as advocates and solicitors within a unified legal system. That's why we in Nigeria is the same scheme of training that we all enjoy. So you can practice both as a solicitor and an advocate. An advocate is someone who represents his client, who speaks for his client in court, while a solicitor can be a legal practitioner that engages in some form of negotiation, writing of correspondences, legal document, and so on and so forth. Then the last one is the military influence. The impact of the insistent intervention of military in Nigeria political development can never be erased, because when the military government took place, it affected quite a lot of our operation, or affected a lot of our judicial system. And then we, we cannot but refer to them as one of the things that characterize our legal system. So by the grace of God, that will be all for the historical development of Nigerian legal system and the major features of the Nigerian legal system. When we meet in our next class, we are going to be dealing with the idea of law, that is, law and its role in the society. But before I go, I'll quickly look at the question segment and see how much we will be able to, how much of the answer we will be able to provide for the questions. Okay, somebody said, okay, was asking about the features. We've listed about 8 features to include military influence, fusion of the legal system, geocultural diversity, system of precedent, order of judicial hierarchy, existence of different types of law, duality, and external influence. You can check the recording on the YouTube channel to further listen to the lecture. Now, somebody is saying, sir, another question is that if a court sets a new statute that will change an existing common law, I do not understand that question. Maybe the person didn't frame it properly for us to be able to answer. Then, okay, somebody is saying, I don't understand the part where you said in 1960 brought about formation of a court. Please, can you rephrase? Well, what we said is that the 1960 independent constitution brought about further division of the courts in the various states. And then there was need to appoint judges, even though as at that time, the Privy Council was still the head of the judiciary or still serve in that capacity. But those were the major features under the 1960 Constitution. Then someone has said, if a person isn't satisfied with the decision of the West African Court of Appeal, could he or she go to the court, the Privy Council? Yes, as at that time, yes, we could go because the Privy Council was the highest court in the land as at that time. Yes. Okay. I think that's all I can see here. One said the Royal Niger Company started as National African Company, but sir, I thought it started as a United African Company, but was later renamed as National African Company. If you read the history behind it, you will also know that even before the United African Company, there were other, how it grew, all of that. We just picked from one particular portion, not all of it. Yes, Blessing, let me take your question and we call it a day here.
Good afternoon, sir.
Good afternoon.
Sir, about the features of the Nigerian legal system.
Yes.
You're talking about number 4, that is precedence. Sir, can you please come again? I didn't quite get you. My network broke off.
About what?
The precedence.
I didn't get. I'm trying to. Okay, one of the features.
Yes, sir.
Yeah, we talked about the system of precedence, where we did say that it's part of our own legal system, because in our system, of course, we brought that in through the common law. God, judicial precedent, stare decisis has its origin in the common law. So, and what the judicial precedent simply means that a lower court is enjoined to follow the decision of a court, of a higher court in a similar matter. Okay? So that is what we mean by the system of precedent. So with that, I call it a day for today. And while we meet
So,
in our next class,
sir,
we continue from the idea of law as its law and its role in the society. So thank you for listening. I have the attendance covered by the attendance provided by Zoom. So there's no need for you to provide attendance. Thank you and enjoy the rest